It's the Gizar, the always the get flizzar, the whizzar, decking the boy is the tizar, destined to get the winses, finses, clearing up all the lenses. One path is the way that I'm taking, getting closer to God in a tight situation. Part 3 of Paper Arrows, Holder in Due Course. UCC 3305 is titled The Rights to Hold in Due Course. To take to the extent that a holder is a holder in due course, he takes the instrument free from all claims to it on the part of any person. Remember that this section is called the rights of the holder in due course. When one person takes the instrument free from all claims to it by any other person, means that if I brought the property, I do not have any right in the property because I do not even have a right to claim anything on it. Property is defined as the right to the use of a thing, not the thing itself. If you fill out anything such as a voter registration that identifies you as a body and leave the instrument in the hands of the government, they become the holding due course of that instrument, not of your body itself, the instrument. They take the instrument free from all claims to it on the part of any person and acquire every bit of right in the property identified thereon, your body. We do not have any right in this country of property. Thomas Jefferson made a good comment: without property, there is no liberty. Freedom when fee paid. We equate liberty with freedom, but that is not really an equation. Freedom is what we have in America. We have a lot of freedom. You are free to drive provided you pay the fee to get on the roads. You are free to work provided that you pay the fee to work, called income tax and Social Security. You are free to go fishing provided that you pay the fee for the license. The same is true for hunting and other freedoms we have in America, liberty. But you are not at liberty to do anything because you do not have any property. Without property, there is no liberty. Their roads. The police have told me that I could take my car home and start it up in the driveway and execute my right to travel all I want, as long as I did not get off my property and come out onto their roads. Good point. Right to travel. On my property, in which I have a possessory interest, I have a right to travel. I can travel from one end of it to the other end of it. I cannot cross the line and go into someone else's property. That would be trespassing. If the state has deeded the land for the roadways to itself, then it is the state's private property, and I need a permit called a driver's license to use their property, or I will be trespassing. This is another example of how we have been robbed in America. When you identify your property on this instrument that you are filling out, such as an application for registration of a car, and then it is signed by you and handed over to them, you have transferred the property to them, but you thought you were transferring it from the dealer to you because it said that on its face. If the state takes the paper and holds on to it in the middle of the transfer between me and you, the state becomes involved in the transfer and the state ends up with the right in the property. That is called fraudulent transfer. Fraudulent conveyance. It is covered by a statute called fraudulent conveyance statutes. This is defined in the law dictionary as a conveyance or transfer of property, the object of which is to defraud a creditor or hinder him or to delay him or to put such property beyond his reach. A creditor is one who puts up the value for somebody else. It was your car. If you were selling it to me, you were putting the value of your car up to transfer it to me. I am the debtor. I'm going to owe you for the car. The state gets in the middle of this transaction and hinders you from being able to get the full value of your car as a creditor. That is called an unlawful conversion. Unlawful conversion. An unlawful conversion is what occurs during an unlawful conveyance. Look these words up. Conversion. A conversion is an unauthorized assumption or exercise of the right of ownership over goods or personal chattel belonging to another. What is the state doing with these instruments? They are perpetrating an unauthorized assumption or exercise of the right of ownership of these automobiles. The state is receiving the right in the property. If they are taking the right of the property, that is part of the right of the ownership, then they are exercising control over your use of the property that you think is totally yours and have the right in. This system is all fraud everywhere. Designed. This system is designed to specifically get the value of every bit of your property away from you. All this can be used as evidence, but it must be explained exactly what the fraud is. This is where we could use some help from lawyers that want to help the cause of liberty. It may require a retired lawyer with nothing to lose to help in this. U.S. versus Heron. There are a couple of court cases that I know of that expose the fraud. One is U.S. versus Heron. The case is about a man who made a lot of money and took it out of the U.S. and brought it back in small quantities so he would not have to pay income tax on the whole amount. He perpetrated a fraud by doing this. This case is an example of what the government calls fraud. It is about hiding truth. This guy would not have had to do this if he had known about the status of being a non-resident alien. His money was made from non-government sources, from private sources, so he did not owe a tax anyway, but he did not know that. Hiding truth is fraud. This case shows that what he did was a fraud because he was trying to hide it. Hiding the truth or right of the property is fraud, and in order to catch him, the IRS perpetrated another fraud themselves. McNally versus U.S. The second case is McNally versus U.S., 483 U.S. 350. This also shows fraud and explains it in detail. This case details tangible and intangible property rights along with tangible and intangible property rights frauds. It shows what a fraud against a tangible property right would do. These cases should be put on your reading list so that you will be able to completely explain fraud and then make a case that shows this fraud in any area that you might need to apply. Fraud is everywhere, and you should practice describing it. Back off. If you begin to put these cases together properly, the government will back off what they would have come forward previous to this knowledge. Trespass. A trespass of any kind is a fraud upon a person or property. Any kind of a fraud dreamed up to be committed on a person is in turn a trespass. Any kind of fraud or a trespass turns out to be an injury to the person that has been trespassed upon or defrauded. Injury. An injury is something that you can take into court and create an action on. A deprivation of personal property rights is injury. An injury is entitled to compensation, money damages. Someone may be able to make a couple of bucks before this whole fraudulent system collapses. Maybe they can burn them in the fireplace when they become completely worthless. These actions may be the paper arrows to shoot over there at Babylon to knock it down. It is necessary to review several definitions in order to define fraud. One of the words is scheme. Scheme. A scheme is a design or a plan formed to accomplish any purpose at all. A system. When used in a bad sense, the word corresponds to trick or fraud. A scheme to defraud within the meaning of the mail fraud statutes. It is the intentional use of fraud or fraudulent representation for the purpose of gaining a valuable undue advantage or working some injury to something of value held by another. Mail fraud statutes. That fits all the things that were just discussed, such as motor vehicle registration, social security, voters registration, birth certificates for the children, and other schemes to gain a property value interest in whatever property is identified on the instrument. This whole thing sounded like a sham, so I decided to look up that word, sham. Sham means false, a transaction without substance that will be disregarded for tax purposes. Cannot tax. That means that they cannot tax something that is fraudulent because fraud also means false. This last point by itself could be enough to free the people from an illegal tax system. Since the whole scheme of taxation in this country is a sham, the law says to set it aside or disregard it. Chief Justice of the Supreme Court Cardozo in 1944 referred to the 14th Amendment as a scheme of forced liberty. Today we are finally all equal more than before. We all are property and all equal since we are all held by another, the government, through contracts. Deceit. Deceit is a fraudulent and deceptive misrepresentation. It is an artifice or device used by one or more persons to deceive or to trick another who is ignorant of the true facts to the prejudice and damage of the party imposed upon. We are creating a basis for an action here. By explaining how the deception and fraud took place, we can then show that we have cause to be compensated for the injury that resulted from the deception that they perpetrated. That definition of deceit mentioned the word artifice. Artifice. An artifice is an ingenious contrivance or device of some kind, and when used in a bad sense, it corresponds to trick or fraud. The instruments of the systems mentioned before, such as Social Security, voter registration, and all the rest, would certainly fit into that definition, into the definition of an artifice as being a device of some kind to trick or perpetrate a fraud because you were tricked into using these devices, and you have given up your property for them to hold to the detriment or prejudice of yourself, the party imposed upon. These documents that the government calls valid are artifices. They constitute a fraud. Fraud. Fraud is an intentional perversion of the truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him or to surrender a legal right. When you file your deed in the public records, the court, you surrender the legal right to the property. By the artifice, the application, and the misrepresentation of law, you are induced into that. You had better do these things or you will be arrested and put in jail. You refuse to do them. So you did them under duress. Actionable fraud. Actionable fraud is deception practiced in order to induce another to part with property or surrender some legal right. It is a false representation made with the intention to deceive. It may be committed by stating what is known to be false or professing knowledge of truth of a statement which is false. In either case, an essential ingredient is the falsehood intended to deceive to constitute an actionable fraud. It must appear that the defendant made a material misrepresentation that it was false, that when he made it, he knew it was false, or made it recklessly without any knowledge of its truth, as a positive assertion that he made it with the intention that it should be acted upon. The plaintiff acted upon it and relies upon the truth that he anticipated it had, and that the plaintiff thereby suffered an injury. If you study that closely, it sets up the basis of your whole case. Injured. Because we have been injured by the loss of our property by being compelled by misrepresentations of law into participating in all of these government things that identify our property, and we lost the right of our property, we have suffered a loss because of the misrepresentations. No false contracts. They cannot make you contract with them by any means. No law can be passed that states that you have to make a contract with them, but they are getting away with this stuff because we are afraid of them, and they're going to get away with it, and you are never going to win as a defendant. The only way to win is to go after them for fraud. You become plaintiff. If you are the plaintiff and they are the defendant and you accuse them of fraud and you ask for $100,000, it's going to scare them so bad that they are not going to answer you. A failure to answer a case is a win. The court has backed off the case in Michigan for now. They are not going to play with this thing. They are afraid. In that case, Mr. Sapp cannot go to court to sign an order for possession. He's going to lose his $13,600 that he paid to the IRS for the property since he cannot take possession of it. He's going to have to sue the IRS to get his money back. He is definitely not happy about that. Injury. An injury is any wrong or damage done to another in his person, his rights, his reputation, or his property. If you have received any kind of an injury, then you have the right to file for compensation in a court action, even against the government. U.S. versus Twill. A refusal to answer something is silence. In the court case of U.S. versus Twill, the judge said silence can only be equated with fraud, where there is a legal or moral duty to speak, or when an inquiry left unanswered would be intentionally misleading. We cannot condone this shocking conduct by the IRS. Our revenue system is based on the good faith of the taxpayers. Government workers and the taxpayers should be able to expect the same good faith from the government in its enforcement and collection activities. Silence is fraud. Good faith. During the oral arguments, counsel for the government stated that these practices of silence were routine. And if that is the case, we hope our message is clear. This sort of deception will not be tolerated, and if this is routine, it should be corrected immediately. We just learned that fraud is actionable, and we could create a case with fraud as the basis. Silence is actionable. Silence by an official or police or anyone else that will not answer your question results only in an attempt to defraud you by some scheme to defraud, and is itself grounds for an action, just as fraud is actionable. Security instruments. There is another case that lines itself right up with the Erie Railroad decision, but it also includes some real interesting comments about the situation that the government put itself in by dealing in these security instruments, such as deed, certificates of title, and insurance policies, like Social Security. Those instruments are called security instruments. The fact that the property is identified on there secures the property interest that is identified to the name of the party appearing thereon. That is why they are called security interests. Clearfield government. The Clearfield doctrine refers to the Clearfield Trust Company versus U.S. expressed. The government descends to the level of a mere corporation and takes on the character of a private citizen with private corporate commercial paper securities. That means no immunity. That means that they do not have any immunity. They are equal to me and you. They are right on a level with us. Name on instrument. If our name appears on a security instrument and their name appears on a security instrument, They are the same as us. They have no more rights than we do. We have no fewer rights than the government does. Most people think that the government is superior. This case states that the government is equal. No, falsely elevating the government to our level is really stretching it. Clearfield Doctrine. Quoting Clearfield again, for purposes of suit, such corporations and individuals are regarded as an entity entirely separate from government. Very interesting case. Now we can understand why the civil rights legislation waived all immunity for government agents. The only way that they are committing a deprivation of your rights is by written instruments. Everything they do to you is based on some written instrument. Everything. Courts must have a contract first. The court cannot acquire jurisdiction over a case unless there is a written instrument involved, assumption of a contract or agreement, such as residency. Residency is a conduct, and they always have to establish residency in order to prove to the court that it has jurisdiction over the issue and the person in front of it. A man in Tennessee would not admit that he was a resident of Tennessee, and the judge got so frustrated that he even asked the man where he slept in order to establish residency. The judge was trying to get him to admit that he slept in Tennessee to residency. Finally, the judge threw him out of the court. He could not establish residency. When he could not establish residency, he could not prove jurisdiction over the man. Civil rights case. So you can put together a good civil rights case showing and exposing how the fraud created the injury. You can show that they are equal to you without their having special or particular immunities because of Social Security applications, IRS 1040 forms, vehicle registration applications, and other license applications and various other forms used by all governments and at all levels. Have no immunity. These government entities, such as the IRS, are all equal to you and have no particular immunities. By their silence, they have proven their involvement in schemes to defraud you. This action, according to the Supreme Court, cannot be tolerated by the court. Triple damages may be in order here. A tax bill triple could be awarded. The courts would not argue with it. The courts know racketeering when they see it. RICO may apply. 26 United States Code Section 6323. Look at how this fraud works and fits into some of the law. There is a statute called Federal Tax Lien Act of 1966. It has been codified in Title 26, Section 6323, and USCS, United States Code Services, under Sections 6323 and 5. That was found to state the purpose of the Federal Tax Lien Act of 1966, which is codified 26 USC Section 6323, was to fit tax liens into the priority scheme of the Uniform Commercial Code. This came right out of the Book of Law, USCS, UCC in Title 26. This is not someone's opinion. It is in the statutes, the codes, UCC and IRS code. For all of those that think the UCC does not fit into the IRS code and cannot be used simultaneously with it, that is what the code states. Title 26 is the IRS code. Read it again. The Federal Tax Lien Act was created to fit tax liens into the priority scheme of the Uniform Commercial Code. 26 USC Section 6323, transfer property. Continuing from USCS 6323, the purpose of filing a notice of federal tax lien was not to create the lien, but only to maintain its priority over certain other liens. The fair intendment of the predecessor of 26 United States Code Section 6323 is to permit the transfer of property, both real and personal, belonging to the person who has neglected to or failed to pay the tax without a real lien of government in taxing the property. People have been saying for years that a notice of tax lien is not worth the paper it is written on. Self-abnegation. Continuing the quote, predecessor to 26 USC 6323 was an act of self-abnegation upon the part of the government in the collection of the taxes by which it must abide. There is no question of strict versus loose construction that arises. There is no room for construction as predecessor to 6323 as classes of persons was specific. Classes of persons. Abnegation is the act of denial. To abnegate means to deny or refuse a right. It is from the Latin word abnegatus, which means to deny or to refuse. That means it is set in stone and cannot be changed by construction as to the class of person that a federal tax lien can be laid against. 26 United States Code Section 6331. Cross-reference, see Section 6331 titled Levy and Distraint. Authority of the Secretary. If any person liable to pay any tax neglects or refuses to pay the same within 10 days after notice and demand from UCC used again by IRS code, it shall be lawful for the secretary to collect such tax and such further sum as shall be sufficient to cover the expenses of the levy by levy upon the property and rights to the property, except such property as is exempt under 6334 belonging to such person, the one who refused to pay his tax. Is a lien provided by this chapter for the payment of such tax. Levy may be made upon the accrued salary or wages or properties of any officer, employee, or elected official of the United States, the District of Columbia, or any agency or instrumentality of the government of the United States or the District of Columbia. Notice of demand, levy for government employees only. The state of Georgia or any other state is an instrumentality of the United States. State of any state name is the government corporation of that state. Georgia is not. The state of Georgia is the government of Georgia and is an instrumentality of the United States government. State of government, which is an instrumentality of the United States government. That shows the connection of the local governments with the federal governments, since they are all agencies of the one above them. If you work for any phase of government whatsoever, you are covered by the connection of the agencies to the federal government. You are covered by that statement above, and there's a period behind that statement as was stated as to whom it applies. It does not go on to name anyone else as to whom it applies. The statement is very specific. Tax liens can only be laid upon government officials, government employees, and government corporations, not you and me. Argue the fraud. That was part of the argument used in Dan's case to show the rest of the fraud. And that was what prompted the lawyer to say that all the stuff you brought up about Section 6331 is an argument that belongs in a federal court. We knew he was going to say that because it does not belong in a federal court. It did not belong in that little court. It was not relevant to the case of a guy having a deed and wanting a writ of possession based on the deed he got. Section 6331 is not relevant to that case, but it is part of the counter complaint to show that he got the deed by fraud, and the setup was to say, fine, we're going to have a federal case, and this guy, Mr. Sapp, is a co-conspirator in the fraud, and we certainly hope that the court does not intend to become another co-conspirator of the fraud with the IRS. When the lid is put on that box, there is no way out. And at this moment in time, we're going to pause right here on page 42 at the point where it says lay out the cases. I want to thank you very much for your time, your patience, and just bear with me. We're going to get better and better at what we're doing. Peace and blessings, people. Peace and blessings.